letter, which I treated as an objection. I received that letter from Ms. Stoner, Beth Ann Stoner. I received it actually on October 26th. It was dated October 11th. And on the basis of that letter, then I scheduled this hearing. I don't know whether or not y'all had a chance to look at that letter.
Yeah.
I should indicate for the record that Ms. Stoner is present today, as is Mr. Godfrey, Ms. Tina Mullins, and Mr. Malampy. Is there a bookkeeping error here, or is it?
If I may speak, Your Honor, I don't think so. It just appears the letter is a rethinking of her settlement, Ms. Stoner's settlement, wishing that now that she would settle differently. So I don't think there's any issue about how the money was dispersed. It was all dispersed pursuant to your court order, the order of the court dated September 11, 2006, and there's no dispute by any party except Ms. Stoner. It's not an issue that the order wasn't followed. She feels that she wants a different deal today than she agreed to on the record back in August.
Ms. Stoner, are you still represented by Mr. Godfrey?
No, I'm not.
All right. Do you wish to speak for yourself with regard
Yes,
to this?
sir.
Go ahead.
Okay, there is a bookkeeping error. This is, I don't even know where September 11th information came from. I was never advised of that. On August 23rd, 2006, for the first time, Your Honor, in more than 27 years, my family actually came together and agreed on one thing. I was asked if they could receive $26,000 each, $20,000 to Mr. Godfrey, $20,000 to Mr. Malampy, and I received no information on Ms. Mullins, what she wanted, so I'm assuming she wasn't asking for anything. And I had no problems with that. The only additional money that I was informed was when I actually closed out all the accounts, there would be a gain from the interest, and that would be equally divided amongst all 6 of the beneficiaries. I agreed to this. And then it wasn't until October, when the checks had been written, was the first time that I was informed that they were getting over $28,000 each. The agreement was $26,000 for the 2 petitioners and the 3 other interested parties.
Okay, let me stop you there. Is she correct about that?
I don't think she's correct about any of that with respect to what is in the court order. What she's saying now, Your Honor, is not anything, she's not criticizing anything that was done with respect to the court's order.
I'm confused.
We followed the court's order. What she's describing as these other agreements and other understandings are not what she agreed to on the record.
Okay, so that's my question.
Yes.
What was agreed to on the record?
What is in the court's order?
I didn't even speak on the 23rd. You asked questions of 3 interested parties only.
Well, but you were represented by an attorney.
He never said anything either. He was sitting right here.
Well, but I only asked the questions of the other interested parties because they were not represented. The attorney was here to speak.
Correct.
Your Honor, I did come in and review the record, the transcript of the record, and Mr.
Is there a
Moore-
transcript?
Well, the video transcript.
You reviewed the videotape.
Yeah, I reviewed the videotape to go through and make sure what was said on the record. And on that, it stated that, like she said, $40,000 in attorney fees, and the balance to be divided equally 6 ways. And there was some discussion about actual figures, but it was all subject to whatever the final outcome was. But it was always to be divided 6 ways. You gave opportunity on the record at least twice for any objection. And on the record, you also said any objection to this order must be filed within 7 days.
But
Well-
if I'm not notified, I can't object.
Were you here?
I was here on the 23rd
That's what we're
of
talking
August.
about.
That's it. The figure brought to me was $26,000 for 5 of the beneficiaries.
So you're saying that is that what was stated on the record, 26,000 for the beneficiaries?
No, Your
No.
Honor.
Okay.
Yes,
You say that was stated on the record?
absolutely.
Okay, so let me ask you this. If you're wrong, then can I assess you for their attorney fees?
No,
Well, are you right or wrong?
I'm right.
Okay, so if you're right, that means you're basically, you had everybody come here based on what you say was said on the record. And if that is not correct, then it seems fair to assess you for their attorney fees. So I will look at that tape, okay? I will look at it, and you can look at it too. We'll look at it right now, and we'll see what was said, if that tape does say 26,000 to each, or if it says what they say it says, which I think is to be divided equally.
Yeah, plus or minus whatever, however, it's liquidated, because these are assets that had to be sold. And that was what Mr. Godfroy did with alacrity, and whatever that amount was. There was no agreement that she was only gonna pay 26 grand.
Mr. Godfroy approached me with a figure of $26,000, and I agreed.
Okay, well, I don't know about that. I only go with what is said on the record, okay? If there's some misunderstanding regarding the communication, that I can't deal with. That's why we record these things. So my job is to either settle the case myself, basically divide it up myself, or to have the attorneys and the parties who are not represented come in and tell me what their agreement is, and then my job is to make sure that the order that I sign conforms with what was said on the record, okay? So I'm going to look at that to determine whether or not what was said, and you can look at it with me. What time is our next hearing right now?
Yes.
Are they ready?
Yes.
Okay. Is it next two already? All right, would you get that tape ready, Tom? That should be the August 23rd?
Correct.
Correct.
Yes.
August 23rd tape. And just cue it up, Tom. Come here. Off the record, please. Okay. Cue it up in my office. Lawrence and Patricia Stoner Trust matter. The last 15 minutes or so, I have reviewed the tape from the August 23rd proceeding, and I believe also reviewing that tape, present in the court while the tape was reviewed were Mr. Godfrey, Ms. Mullins, Mr. Malampy, and Beth Stoner. Ms. Stoner, is there something that I didn't see on that tape which...
Okay, first, after hearing the tape again, I'd like to apologize to everyone that I misunderstood what was being said to me that day, considering my blood sugar was over 600, and they were all aware of that. And I'm assuming you were too.
You're assuming that I was aware your blood sugar was over 600?
My attorney told me he informed everyone that I was very ill that day, and that's why we were trying to settle this, because I was actually too ill to be here.
I did not know that your blood sugar was over 600.
Oh, yes, sir, I just found out in July I am a diabetic.
Okay.
It's out of control even to this point. But I trusted him to take care of me, and I feel Mr. Godfrey failed to do that because it was a $26,000 statement when we walked into this room. And then suddenly, I heard today, and I'll admit, it suddenly got divided equally. I have no problem with an equal division, but under that equal division, if we're going to revert back to the original trust that was put in place by both my parents, Michael owes $20,000. And that money was memorialized in writing by his attorney, Miss Mullins, and placed, there was a 3-attorney panel that they went before trying to settle this, and she memorialized it in writing. He owes the trust $20,000.
That's another matter that's not...
But if you're gonna do an equal division, then he has to pay back the loan, and it was a loan, and he acknowledges the loan.
I don't know anything about that.
She does.
Okay, well, just a minute. He's not here, okay? I'm not gonna discuss that today. What I'm trying to figure out now is the objection that you raised in your letter here to the court, your letter dated October 11th. That's
Correct.
only trying to resolve those issues. It does appear, again, that
I'm not trying to use my illness
it
as
does
an
appear
excuse.
that the agreement that was placed on the record is that the proceeds would be divided equally between the 6 of you, and I believe they thought it would be somewhere between $27,000 and $28,000 was the estimate that was stated on the record at that time. So I don't know what your complaint is.
My attorney told me it was $26,000 $26,000.
Okay, no, so,
As a matter of fact, when Ms.
hang on a minute,
Delmonte.
stop. Assume that he told you that, isn't it 26,000?
26,000 to the 5 beneficiaries.
Oh, I see what you're saying. I see what you're
They
saying.
each asked for 26,000.
I see, okay. But did you hear him say on the record, and everybody else say, that it was gonna be divided equally 6 ways?
Today, yes.
You didn't hear that the other day?
That day, like I said, I wasn't here mentally.
Oh.
I was very ill, and I'm not gonna offer that up as an excuse.
All right, well, all right, I find no basis for the objection. I don't know, is there anything left to be done in this estate?
Yes. One part of your order, Your Honor, indicates that all parties agree to sign a mutual general release of all claims to memorialize their release that was verbally placed on the record on the 23rd. All the parties have done so. I'd ask that the court order Ms. Stoner to sign this so that I can then distribute it to all the parties. Some of the things she's mentioning are things that all merge in the settlement. Prior claims for this and that, or the settlement concludes everything, and that's why we had on the record, everyone agreed that there'd be a general release, and everyone would sign a general release as well.
Well, I think what your statement was is you were gonna try to get them to sign a general release. I think that's what you said.
Correct.
I don't know if I ordered that.
Very good. Well, I'm here to try to do it.
Okay, well, I'm not gonna compel someone to sign something. I mean, the court, I think the court order speaks for herself. She can sign it if she wants. Presumably, she's gonna get the benefit if she signs it, but I don't know. I mean, I don't believe I ordered that. I think the only reason I say that is because you didn't say each party shall sign a release.
The order that all parties approved for entry says that all parties agree to sign a mutual general release. So that's
Okay.
not your order, but it's her agreement, and I'd like to enforce her agreement here
All right.
today, if we're able to do that.
Well,
I brought mine with me, so I
Did
can
you?
sign it. Yep,
Okay.
absolutely, sir.
All right.
I mean, I'm prepared to sign what they need to be signed,
Okay.
but I had questions.
okay, any other problems then with regard to this estate? There was some stipulation people talked about.
Judge, I am still holding in my client's trust account $6,918. That is the remaining sums out of the $8,000 that I was to hold. And I'm ready to issue a check and provide it to Beth Ann Stoner for the $6,918, but the issue is cost and what other expenses the court wants to order out of that. But I have not released those, that's all I have left in my client's trust account. I took all the money in and I divided it 6 ways, made the distributions, held back the $8,000 that the court order said I was to do. We got all the tax returns paid.
So, okay, should Ms. Mullins, Mr. Malampy, should Mr. Godfrey distribute that sum to Ms. Stoner? Any objection to that?
We'd ask the court to consider costs of $500 for the Thomases for my time to be here.
Ms. Mullins?
Nothing, Your Honor.
And I object.
Okay,
Oh, sorry, ma'am. Your pen. I think I've paid enough. More than enough. And honestly, Your Honor, I can't afford it. I'm paying for my medical care out of my pocket. And another problem I have with that, Susan had a choice in this matter, to hire an attorney or not. I had no choice. I was forced. So I feel I have paid more than enough financially, mentally, and totally physically.
Mr. Malampy, how much time have you expended to address this objection?
9:15 this morning until I get back to the office, which will be 11:15. It's 2 hours. I bill out at $250 an hour. That's where I come up with $500, Your Honor. Whatever in your discretion you think is appropriate, we leave that in your hands.
All right. Well, again, there's a number of ways I could have handled this. And it was difficult when I get a letter like this and somebody is accusing their attorney of, not responding to them. Really, the only thing I can do is get everybody in here in open court and address it. I'm afraid that if I had simply looked at the tape myself and told Ms. Stoner, that's not what the tape says, I'm basically not honoring your objection. I'm afraid that she would not have been, I don't think she would have felt like she got a fair shake. And that's why I want everybody in here for that purpose.
Actually, that's what I was hoping you would do.
So that's what I did, and the problem is that the objection was not based in fact. It did not say that defendant Beth Stoner would receive $38,402.86. I don't know where she got that number, and so the question is then, what's the appropriate, why should Susan Thomas have to pay an attorney to be here to, she didn't cause this. Ms. Stoner caused them to have to be here based on her objection, which was not based in fact. The court rule allows for the court to assess costs against attorneys and parties, actual costs, for pleadings that are not based in fact. This is one of those occasions. I am going to assess $200 per hour. It would be $400 to Mr. Malampy for the funds expended on behalf of Susan Thomas to be here today to answer this objection that was not based in fact. The balance then, Mr. Godfrey, should be forwarded to Ms. Stoner that's in that account.
Can he do that today so I can get the check and go home?
Mr. Godfrey, any objection to that?
No objection, I can do that. I will issue the check for $6,518 to Beth Ann Stoner.
All right, thank you. Anything further?
Yes, we received from Ms. Stoner her original signed mutual release as I was requesting.
All right.
An agreement. I'll make copies of this and provide it to all parties and Ms. Stoner so she has a copy.
You want a copy right now?
Yes, before it would be ideal.
Mr. Bale, would you do that for us, please?
Thank you. Probably about three. Nothing further.
Anything further then? All right, thank you. We're adjourned on this matter then, thank you.
Thank you.
Very well, Your Honor.
Thanks, please.